Welcome to another episode of Cash Counsel. This is Joe Cordell, and as some of you perhaps know, we have a weekly show on DadsDivorce.com. We also have this appearing on a couple other websites. And the purpose of this show, Cash Counsel, is to talk about ideas that relate to executive asset protection. I use the word executive asset protection because some of these techniques are more applicable to people who have more assets, who have perhaps, I'll grab a number, maybe assets primarily in excess of $500,000. It's not that some of the things we're going to talk about here couldn't be helpful to all of you. They can. And particular items or particular tools you'll find will be wonderfully helpful to you if you have a problem and yet less money than that involved, because some of them are relatively inexpensive to implement and they're hugely protective and helpful. But in terms of the program as a whole, when lawyers speak about asset protection, they're generally talking to clients who have assets somewhere above $500,000. Not a magic number. It could be less, it could be more, but that's just a ballpark estimate of what we see. So in talking about executive asset protection, I want to take you through the steps. And last week, for those of you who viewed it, if you haven't, go back and see the first episode of the Cash Counsel show. And I do a sort of global or aerial view introduction of this area of the law. And I think that you'll find that's a wonderful starting point in order to understand these subsequent episodes. However, I'm going to recover some of it periodically, not only because I think perhaps you didn't see the first episode or you haven't heard this before, but I think it bears repeating. And some of the basic concepts here do bear repeating. So I'm going to kind of call this discussion executive asset protection planning. And I'll sort of walk you through this. At some point we'll have a PowerPoint. I've prepared notes here that I'm viewing as we go along, and I think at some point in the not too distant future we'll be able to put that up on the website. So look for that. Who needs asset protection? We talked about that a little bit last week, but I want to cover it again. Generally speaking, professionals are often people who choose to have asset protection plans. Business owners, a very common tool or component of their business plan is asset protection. Executives of all sorts who are engaged in business contracts and other activities that expose them to liability. Real estate owners, and I don't think I need to tell you the risks that accompany owning real estate, and I know that applies to many of you. But protection from what, some people ask? Well, personal injury litigation. America's notorious for that. Statistics show that personal injury litigation has actually been a deterrent to companies practicing or having as their corporate headquarters the states. Studies have shown that a number of major corporations worldwide think that America is a dangerous place to do business. Surveys suggest that America is losing into the hundreds of millions of dollars in revenue based on this perception worldwide that this is a dangerous place to do business. In other words, it's a place where there's a great deal of risk for litigation, business litigation, personal injury litigation, employee litigation, a variety of directions from which those lawsuits may come. Business litigation is another protection from what? Business litigation is very common. Doesn't relate to somebody suing you because they allege you hurt them. It can be just a bona fide dispute. We're a litigious country, and we tend to litigate things a lot. That's the reason we have so many lawyers, much to your chagrin, perhaps. Employment-related litigation, very common, particularly in the area related to civil rights, related to other discrimination issues. General creditors, and that's just kind of a very broad umbrella. It just says that anybody has a creditor, whether you're engaged in business or not. Anybody has a creditor has some creditor risk. Spouses and ex-spouses. Certainly those of you who are dealing with Cordell and Cordell, you know that that's an issue. And there can be some planning that's done in advance of that, believe it or not. It's relatively uncommon, and there are a number of constraints on that planning, but it certainly can be done. And we encourage those people who are sufficiently anticipatory to consider those ideas, and our attorneys are happy to talk to you about that. So spouses and ex-spouses. Government claims that can be from any number of agencies, IRS, SEC, EPA. Anybody who's had the unpleasant experience of dealing with the EPA as a landowner knows that that's a bottomless pit of potential liability. OSHA is a direction from which litigation comes, and a myriad agencies that can appear out of the woodwork, and you be assessed with fines and penalties, etc., for things perhaps you didn't realize you were in violation of. It's just the world we live in. We talk about asset protection. We live in a dangerous world. That's the bottom line. So the bottom line is we live in a dangerous world, and litigation can come from a variety of directions. Who's the target? Well, the target is you and your family, is your family's wealth. And if you're looking at a family that's potentially dividing through divorce, then it's your wealth versus hers. Let's talk about some of the issues in terms of protection planning overview. What does that consist of? Well, I'm going to walk you through the steps. Here's the way I would describe a sort of protection planning overview. The objective is to get to the plan implementation stage. But you start out by meeting with an attorney in which you talk about your circumstances and objectives. And everybody's a little different, although there's a lot of common denominators. Often when somebody comes in and meet with us, once we get a sense for what they have in this world, we can predict pretty well what their goals are. It's pretty much the case with domestic relations clients. But it's not always true. I mean, sometimes people want to do things that perhaps we wouldn't have anticipated, to protect things or to give money away or other issues. So we want to talk, first of all, in the process to you about your objectives and your circumstances, two different things. And finding out your circumstances means completing a series of forms. Now, our lawyers may fill that out, or if you go somewhere else, that lawyer may fill it out, but it's critical that you be prepared to give them information. Now, in that initial meeting, it's often not the sort of detail that will ultimately be required for the finalized planning. So you don't need to feel a responsibility to bring in all your documents, but you got to bring in sufficiently specific information so that the lawyer can develop a sort of general idea of what direction you want to go. You don't have to walk out of that initial meeting with a final specific concrete plan. That's unusual. Usually you walk out with a plan, but it's more general, and it's subject to modification as the attorney and you obtain additional information in this sort of, for lack of a better word, this discovery process. So the early stages, when you come in, you make your appointment, you'll be asked to bring documents. And to the extent you have a statement showing your bank account balances, to the extent that you have a recent real estate appraisal, you don't so much need the appraisal as you need the number. Because what your lawyer is going to rely on in that initial meeting is to get a global overview of where you sit in this world. What are the directions from which potential liability will come. And you don't get to that step without figuring out what you own. And then, of course, the final stage of that initial meeting is talking about your objectives. So that's the first phase of the sort of protective planning overview process. A second phase is going to incorporate a couple of things. It's going to incorporate the tools, the tactics, the techniques that asset planners use. And that's where they integrate the skills that they have, or the tactics that they have, or the tools with your particular circumstances. And they put these together, including site selection. Then they'll come up with a plan that's kind of tailored to address your needs. And I'm going to talk in a few minutes more specifically about the tools and the tactics and the techniques. I think those will be helpful. But I also want to take a few minutes here and mention site selection. Site selection has a lot to do with jurisdiction. We talked last week a few minutes about the fact that jurisdictions vary. They vary in terms of their corporation law, and those laws may be more protective against creditor rights than others. They're different in terms of how they honor trusts, how they treat revocable as well as irrevocable trusts. There are a number of key points where a certain jurisdiction can make or break your trust if a creditor comes after you. So to the extent that you can incorporate in that jurisdiction or create that as the situs of your trust, that means you would have your trust reside there. You'd have a trustee there. You'd have some of your assets in that state. I mean, that may make the difference between whether or not a particular structure for you withstands an attack or whether it fails. Some states, as we talked last week, are very anxious to pursue the asset protection business. They recognize it as a potential boom to their economy, and as a result they want to lure those dollars to the extent they can. So Delaware has always been a state that has pursued corporate and business investment, and so they, not surprisingly, have asset protection statutes that are very helpful, particularly as they pertain to trusts and corporate structures and limited liability or limited partnerships. But also, Alaska's gotten on the bus recently. Nevada has shown a great deal of interest in this area.